Hanson.
Good afternoon. For the record, my name is Mark Hanson on behalf of the Appellant 1 at DPL Steve Marinko General Partnership. This is an appeal of two final orders. The first order, which is an order determining entitlement to costs and attorney's fees in the case below, effectively denying costs and fees to my client. Second is a final judgment after a hearing awarding the amount, determining the amount of fees to be awarded to the association, appellee. Both orders are I submit, infirm for a variety of different reasons, subject to reversal here today. Let me address the cost first. Denial of cost. This is a case in which there was an initial hearing that resulted in a June 28, 2011 order. The case went to trial in that order, as well as some other collateral issues. At the end of the day, a judgment was rendered in favor of the plaintiff in sum of approximately $13,000. So there was a judgment recovered. Under the statute 57041, the party recovering judgment is entitled to an award of fees. This court in Wolf versus Culpeper Construction essentially further codified the requirements of that statute, cited Henry Tractor, I believe it was, which was a Supreme Court case that had espoused the fact that the statute is and has been unequivocal and should be applied according to its plain terms. And so that decision was, I believe, was rendered on November 28, 2012.
Right.
I have that right, the year correct, thank you. And so it was in place at the time of the rendition of the order denying costs, the order determining entitlement to fees, which was, I believe, December 28th of the same year. There is no waiver of that claim. There's no case law supporting a waiver. Of course, is a voluntary relinquishment of a known right. The real issue here is whether or not the issue was preserved below, to the extent it needed to be preserved because it's a legal issue rather than an evidentiary issue. Clearly, it was preserved. It was in the motion filed with the court to tax costs and fees on behalf of the plaintiff. It was argued at the hearing. The statute was provided to the court, and so forth. So clearly, that issue was preserved. That based upon plain language of the statute, the plaintiff, having recovered judgment, is entitled to costs. In the case, one case cited by the other side doesn't have any application to that principle. Doesn't change that. As to attorney's fees,
well, your opponent talks about a $20,000 escrow.
I wanted to discuss that, Your Honor.
Argues that that is some type of legal set-off.
Yeah, I wanted to address that. Frankly, I'm glad you brought it up. I had intended to address later on. Yeah, they're referring to some kind of an alleged net judgment. First of all, there was no counterclaim here. There's no affirmative claim of any kind against the plaintiff. A set-off under the terms of the case law applies when you have a judgment, you have a collateral source payment, for example, that's determined post-judgment, such as in a PI case. You've got medical records, you've got other ancillary income, or perhaps there's a settlement set-off of sorts. That's post-judgment. Here, there was no claim for set-off. There was no post-judgment determination of set-off. There was no collateral sources. There was no recognized basis for set-off.
Was there an actual judgment entered in favor of your client for $12,500?
Yes, yeah. At the end of the day, that was it, not subject to set-off. Now, the other aspect of that I need to bring to the attention of the court is the fact that the escrow agreement was not before the court at any time during the pendency of these attorney fee proceedings. The escrow agreement document was not before the court at the time of the hearing on entitlement. The escrow agreement was not before the court about a year later when the hearing was held on the determination of amount, even, so that it be properly part of the record in this case. The purported escrow agreement, well, there was an escrow agreement, but a document was filed post-judgment before this court, and I submit that is highly improper and in violation of Rule 9.200 and not properly of a consideration by the court. So I need to say that. I wanted to say that, and there's case law on that the court may be aware of that talks about the inappropriate nature of collateral items being filed and injected into the record post-judgment. To me, it's a serious issue and one that I'll leave to